On this episode of Law Weekly, we revisit the issue of controversial court orders and why it persists. My guest is a senior advocate of Nigeria, Dele Additional. The Chief Justice of Nigeria, Justice Tanko Mohammed, had drawn more attention to this issue at the recent swearing-in of the Chief Judge of the FCT. We also have a recap of some of the top trending legal stories. Hello and welcome to the program. I'm Shola Shoyeli. The frequency with which conflicting court orders are issued, especially on political cases, continues to agitate many. What is responsible for this and why does the trend persist? In this interview, Senior Advocate of Nigeria, Dele Additional, proffers some suggestions.
First, let me say that there is no problem without a solution. Just as there can never be a question without an answer. But having said that, the problem has persisted because we have not found the right solution, if we have found any solution at all. Talking about a problem, yes, it's okay, but talk only will not solve it. There has to be functional talk. There has to be practical steps taken to identify offenders and sanction them appropriately. Without punishment, people will continue to commit offenses. It is the fear of sanctions that make people to desist from committing offenses.
One of the ways that the CJN tried to deal with this issue was to invite the chief judges of states where we had some of these conflicting court orders,
yes,
and talk to them. And after all of these meetings, we even heard that queries were issued to some judges. Now, the bar on its part also drew attention to it, like you said, and I think they set up a committee. But we've not heard anything after that. Would you agree with those who say that the bar, past administrations of the bar, perhaps the current administration, the leadership of the bar, seems to shy away from identifying and dealing squarely with the lawyers involved who filed these cases before the different judges?
Well, your question is frontal, and you know me, okay? I will not avoid answering your question. And I hope people will look at your question and the answers I'm going to give you objectively. For those who think like you have narrated, I don't think they are wrong. I do not think they are wrong. Are you with me? You say, a serious problem requires a serious solution, pragmatic and realistic solution. Now, yes, it is true the CJN invited some judges, we knew the time. He probably did all that as the Chief Justice of Nigeria, as the head of the judiciary. But when it comes to real sanction, it is the business of the National Judicial Council, right? That is there, as far as the judges are concerned. And at least Nigerians could see that some things were being done along that line. But with regards to the bar, we have the Legal Practitioners Disciplinary Committee. Nigerians must stop being passive, right? Let them take practical steps and write petitions, write letters to the leadership of the bar to say this is what Mr. So-so-so-and-so did, this is what Chief so-so-and-so did, which we think is offensive to our sensibilities, offensive to the practice of law. I'm sure the leadership will not close their eyes to such a petition. I know that we used to have, apart from the Central Legal Practitioners Disciplinary Committee, we used to have clearing houses, of disciplinary committees at different branches, to look at petitions. And any petition where they find out that there is a prima facie case against the person petitioned against, they will refer it to the LPDC. without missing words. Unfortunately, that is the system. Right. If the system says there has to be a petition, there has to be a petition. If there is no petition, the person will go scot-free.
But isn't it time to
But
do away with that practice of waiting for petition?
that is where I'm going when I said but. But it is high time we begin to shift. There has to be a self-mechanism, of getting these things done. For example, if a lawyer appears before a court and the judge or judges or justices, if it is an appellate court, feels that the lawyer has gone beyond the realm permitted by the ethical standard of the profession, without anybody writing petition, the court should be able to refer such a lawyer to the Legal Practitioners Disciplinary Committee. I haven't seen it done, but nothing should stop it from being done. That is when we can become more accountable. It's a profession that pays high premium on ethics, on professional ethics. The code of conduct of the profession is very strict, and it's written in black and white. There is no, is it not?
Because with all
but
of these
our
cases,
enforcement mechanism has to improve,
yes,
to get the desired result. I can assure you, immediately 2 or 3 lawyers are sanctioned. These things will be no more.
yes, because with all of these cases of conflicting court orders that we hear, it was some lawyers who filed those cases, and they are known to members of the legal profession. And I'm not aware, I have not read, I have not heard that these lawyers are facing any proceedings
I've told
to
you
explain.
the reason why. Now, if I'm in this office and somebody brings a matter to me and he wants me to handle it, at our level here, we take decisions. We don't just take any case that walks to our office. I've had cause to reject a Supreme Court case here because I felt I felt it was not a case to be brought to the Supreme Court again. And I told the client, sorry, I have to give this personal experience, but you need to emphasize some of the things we are saying through this kind of illustrations. The client brought the matter here, and I told him, you have a very good case, but the time to ventilate your grievances is spent. It was an election matter. He went to the Court of Appeal and lost. The Court of Appeal gave a judgment and said they would deliver their reasons later. And there was an appeal to the Supreme Court. By the time the Court of Appeal delivered that ruling, it was outside the 60 days permitted by the Constitution. Right? So he came here and he was of the opinion, by the time his appeal was decided by the Supreme Court, both judgments were thrown out, both the judgment and the reasons given thereafter. They said the Court of Appeal cannot give a judgment without advancing reasons. Not being the final court of the land, they also cannot give such reasons after the expiration of the 60 days. So the judgment of the Court of Appeal was declared a nullity. Right? So the client thought that if the Supreme Court had declared the judgment a nullity, they should have assumed the position under the Supreme Court Act and then decide that matter on the merits. I said, you are right. He has personally done all the homework on the consequences of an act being a nullity. I said, you are correct, as if that judgment did not take place. But that is how far you can go. The law also says that the Supreme Court must start and finish this matter within 60 days. They have done that. For you to now want to go back 3 months after the judgment, you are already out of the time. And we rejected the brief. It went to another senior advocate who accepted and took the matter to the Supreme Court. Of course, the matter was thrown out through the window. You get my point? So we have to put energy into the enforcement of our law. Any law that is not enforced is useless in the statute book.
So just like you talked about your law firm doing its checks and internally before accepting a brief, there's also this question that agitates my mind about the judges. I mean, we've said so much about this issue of conflicting court orders. Can the judges who some of these cases come before, can they genuinely claim not to know that there have been similar suits on such cases that are coming to them? Or even when a case is assigned to them, can they go back to do their own checks to find out if if similar suits have been filed on such an issue before sitting on it? I mean, with all that we've said about it, shouldn't the judges also do their own checks?
You see,
individually.
I've done a lot of work about the state of our judiciary and the need for a better administration of justice in this country. Having regards to the situation under which most of the judges operate today, I doubt if they can have time to do that.
Isn't it just as simple as passing it off to their research assistants or the people who work with them, check if there are similar cases on this? They don't have to do it
personally. Do you know how many cases are filed per day in this country? In Lagos State alone, this is October, the cases that have been filed this year, I'm sure, are in excess of 5,000. Most of these judges will have about 20 cases in one day. At the Court of Appeal on Monday, there were 18 cases. I was before that court on Monday. 18 cases. On Friday last week, there were about 9 cases before the Supreme Court. So the problem of the judiciary is both systemic, it's structural, and it's attitudinal. And until we address these problems, it will continue to be what it is.
I hear what you say, but I think we can agree that most of these cases where we have these conflicting court orders are political cases.
I will come to that.
And they are ex parte, the lawyers usually come ex parte. So with that, when the lawyers come ex parte, is it not just as simple as picking a phone call to confirm, maybe from the registry, if there are no cases like this before? I don't know. I think that there should be something in place that a judge can use to cross-check.
I don't think we have that data, functional data, where somebody can press his system, a judge can press his system and know all the cases that have been filed in Lagos. Are you with me? And immediately know the facts of the cases.
Even the admin judge who assigns the cases will not know.
How many cases does he assign in a day? We need to move away from this analog to technology.
Sure.
And once we do that, it's just a matter of pressing your buttons. I remember by the time we proposed judicial, you mentioned it, research assistants, many, many years ago, some of the judges even rose against it.
Why?
They gave a reason. They said that their judgments will be leaking. Whatever system you are bringing, people have to look at the environment. The MBA at the time had to persuade the leadership to say, no, we are not asking that the judicial research officers will be writing judgments, no. But they can assist your lordship in looking for authorities that you are going to apply without the research assistant knowing whether you are going to decide one way or the other. Today it has become a system. So there's a limit to which we can blame our judges. They are operating under a very severe condition. But I think the bane of our problem, if we can summarize it, is one, there is no effective sanction for infractions. We need to step up, not only at the level of the profession, but also, when I say the profession, I mean both at the bar and the bench. And more importantly, the politicians, the clients too, must be answerable. The do or die affair which characterizes our politics in Nigeria has to stop. That's what is giving rise to that. If you want to contest an election, you participate in the primary and you didn't win, go to your home. But here in Nigeria, we want to be the candidate at all costs, even if heaven will fall. That is not rule of law. That is not democracy. So there has to be that willingness to abide by the rules and stop a do-or-die politics.
Now back to the swearing in of the Chief Judge of the Federal Capital Territory, FCT. The Chief Justice of Nigeria, Justice Tanko Mohammed, used the opportunity of the event to ask judges and lawyers to go on self-cleansing and to rid the profession of bad eggs. The CJN says judges cannot continue to issue reckless orders, while lawyers cannot continue to file frivolous suits and engage in forum shopping.
The legal profession should indeed take the lead in all human affairs. However, the lead is at a price. We cannot take the lead when our courts issue ex parte orders recklessly. We cannot take the lead when many litigants, with support of their counsel, engage in forum shopping. We cannot take the lead when counsel file a case before a court that they know lacks jurisdiction, and the judge proceeds to hear the case. We cannot take the lead when counsel files frivolous cases in our courts just for nuisance value or to buy time. Administration of justice is the bedrock of not only democratic or civilized societies, but it also extends beyond the borders of civilized nations. No society can afford to discard administration of justice. There's no regime in any country that can operate without a judiciary. No matter how primitive a society is, it must have its own mechanism for resolution of its disputes. Otherwise, that society will drift into anarchy, self-destruction, and extinction. We must not only do self-assessment, we also need self-cleansing. All hands, therefore, must be on deck from both the bar and the bench to rid the legal profession of bad acts. In recent times, I had cause on a number of occasions to warn judges to desist from engaging themselves in wholesome practices that will erode public confidence in the administration of justice. The rising number of cases filed in our courts is a pointer that Nigerians have confidence in the justice system. The bar and the bench must guard that confidence jealously. The legal profession is the building under which we are sheltered. If we fold our hands and watch others destroy it, or we participate in the destruction, it will collapse on us. We will then have no roof over our heads. May God forbid.
And just before we go, let's bring you a recap of some of the legal stories that made the headlines.
Were available for,
we begin with the report that the Nigerian Bar Association has asked President Muhammadu Buhari to set up an independent panel of inquiry to unravel those behind the raid on the home of Justice Mary Odili. At a press briefing with journalists in Lagos, the president of the bar, Olumide Akpata, warned that lawyers will take legal action if the president fails to act. Against the background of denials from the Attorney General of the Federation, the Inspector General of Police, the Economic and Financial Crimes Commission, and the State Security Service, the NBA also set up its special investigation team to be led by Mr. Monday Obani, the chairman of the Section on Public Interest and Development Law, SPIDL. Mr. Albani, who is also a former NBA vice president, has a 2-week mandate to begin to get answers from the federal government. If indicted by investigations, the NBA says it will call out and discipline any of its members found to have been part of this despicable attempt to ridicule the judiciary. The bar has also resolved to initiate a formal petition for misconduct against the magistrate involved to the FCT Judicial Service Commission to serve as a deterrent to others.
Let me categorically state that the NBA is thoroughly dissatisfied with the denials emanating from the relevant government agencies and departments. And indeed, we reject these denials. And we have vowed to leave no stone unturned in our bid to unmask all those behind this attack and to bring to justice anyone found culpable, no matter how highly placed. If all the relevant government agencies deny authorizing the raid on the premises of a justice of the Supreme Court, then who authorized the operation? Who took the decision to approach the magistrate for the search warrant? What if the team had succeeded and any form of harm had befallen his lordship? Who would have taken responsibility? Today it is the residents of Peter Odili JSC who will be the subject of such a raid tomorrow. It is in this vein that we are calling on the President of the Federal Republic of Nigeria, Muhammadu Buhari, to set up an independent panel of inquiry, a presidential panel of inquiry into this matter. The Inspector General setting up an inquiry is not good enough. He is essentially investigating himself.
Away from that issue, a federal high court sitting in Abuja has stopped the federal government from executing its plan to deduct $418 million from the bank account of the 36 states. The judge issued the restraining order against the federal government following an ex-parte application brought by the council to the 36 states, Jibril Otukepa and Ahmed Raji, both senior advocates of Nigeria. While moving the application, Okutepa told the judge that the states will be completely crippled if the federal government goes ahead to deduct the huge amount from their bank accounts. Justice Inyang Eko has asked the senior lawyer to serve all the court papers on the federal government. He adjourned further hearing to November 30th. In another proceedings, the same Justice Eko fixed January 20th, 2022 to hear a suit filed by the Coalition of Northern Groups, praying for an exit of the southeastern region from Nigeria based on agitations of the proscribed indigenous people of Biafra and Nnamdi Kanu. The group had filed the suit in June, asking the court to compel the National Assembly to hasten the exit of the southeastern region before concluding the amendment of the country's constitution. According to them, the action was informed by the need to stem the tide of violence being allegedly done by the agitation for secession. Still at the same court, another judge, Justice Donatus Okorowo, has ordered the federal government to pay the sum of $1.638 billion to the Delta State government as part of the 13% derivative arrears of revenue payable to the Delta government. The court declared the suit as unchallenged and proceeded to grant all the relief sought by the Delta State government to recover revenue accruing to it. The Delta State government had filed to compel the Attorney General of the Federation to pay 5% of $50 billion recovered as additional revenue that accrued to the Nigerian government. And we round off with the report that the Lagos State High Court sitting in Osborne area in Ikoyi has threatened to jail executives of banks who failed to disclose the amount to the credit of Imagine Global Holding Company Limited, Imagine Global Solutions Limited, and the Nigerian couple Bamishe and Elizabeth Ajetumobi. The two firms and the Ajetumobi couple have been associated with an 11.795 billion naira investment fraud by some aggrieved Nigerian investors who filed the suit before the court. Justice Toyin Oyekon Abdullahi, who noted that some banks are yet to comply with the court's October 2021 order granted in favor of the investors, also warned that besides sanctioning any defaulting bank executive, any lawyer that acts contrary to the order of court also risks being sanctioned. The court's order restrained commercial banks in the country from releasing funds up to 11.7 billion naira to the Ajetumobi couple, who have reportedly fled to Antigua and Barbuda.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I am Shola Shieli. Thank you for watching and see you next week.